Welcome, everybody. This is the third episode, I believe, of Atticus Defends. And today we're looking at a case that has been in the news quite a bit. It's the case of Luigi Mangione, who I think at this point doesn't need an introduction, but we'll go ahead and give one anyways. Luigi is accused in New York State of assassinating the CEO of UnitedHealthcare. His exact motivations are unknown, but it seems to be a mix of his own personal health problems and gripes that he has with the way that healthcare has been commodified and turned into a private industry in the United States. The case has garnered a lot of controversy. There's quite a few people that see Luigi as a villain, but arguably even more people that see him as a kind of folk hero that is going after big business. So we want to take a look at this case from a legal perspective, not from a moral or an ethical perspective, but we'd be remiss not to talk about some of the stuff that is out there in the universe about Luigi. So there's also quite a bit that is unknown about the case, about how the investigation was done, about Luigi himself, and about the actual incident of the crime. What we do here at AtticusAI is we make groundbreaking software that helps people navigate the law. Whether you're an attorney or a business or in the future, even a private citizen, our solutions are designed around particular practice areas to help you attack them. So Atticus is designed specifically for federal criminal. And as a result, we're not going to be looking at the details of Luigi's New York case. But his federal charges are definitely intertwined with his state charges. So we are going to look at specifically the federal charges, but also talk about the case more broadly and even look at it from a societal perspective. So, Mark, I know that when you saw some of the initial footage with respect to the case and you saw what was going on, that you had some thoughts about how the case was being handled from an investigative perspective because of your experience as an attorney of over 35 years. Do you want to speak to that a little bit?
Sure. I took a look at the case from the investigative nature with the way the New York Police Department managed the very swift and very quick reaching of conclusions in the case, the management of the media, and how they were able to put together both the timeline and the way that they ended up in Pennsylvania with the posting from the McDonald's employee through a customer there. And the first thought in my mind was, even though people perceived that there was a long time, 5 or 6 days there where they couldn't find a suspect and were looking for a suspect, as a defense attorney, you have to look at that and the timeline and how quickly in reality they were able to get footage, put together that this was the person who had come from Florida, where he was staying. All those things suggest to me that that would be a way to attack the charges from an evidentiary standpoint immediately, because they pulled together things very quickly, and it suggests to me that I could attack it on a cutting corners kind of management. And so I would first look at how they collected the evidence, do discovery on that, and then a motion to suppress would follow there shortly thereafter. And then if we wanted to, we can just sort of do an overview of what the charges are in the state, what the Fed case is, how we're looking at it from AtticusAI's perspective, and how I would move forward and how we would utilize AtticusAI as a tool in this case.
Sure. What I'll do is I'll go ahead and pull up the Atticus dashboard, and then you go ahead and do the overview. Then we'll get to some of Atticus's recommendations, and then we'll talk about how you would tackle the case based off your experience. How's that sound?
Sounds great.
All right, go ahead, Mark.
I'm just going to reflect from my notes. New York State charges, I'll be very brief. There are murder charges, murder in furtherance of terrorism, murder as an act of terrorism, and murder with intent. There are 7 counts of gun-related charges and 1 count related to the possession of a fake New Jersey driver's license. The federal charges, there are 2 counts of stalking, murder in the use with through the use of a firearm, and that's with a suppressor or more commonly a silencer. There's some debate on why that's called that. and additional firearms defenses. And of course, there's a capital crime in the federal side as well that we can talk about. And then there are Pennsylvania state charges prior to the extradition, possession of an unlicensed firearm. The forgery charge is with regards to his identification, which he presented a false identity. It was a state driver's license that did not include his real name. And then false identification of the police.
I think a lot of people are very confused about two of these charges. Number one, the terrorism charge, and then number two, the first degree murder charge in New York. Dakota, it seems like that's something that was also confusing or interesting to you.
Confusing, yes. More than interesting. I think the interest came from the confusion, but the terrorism especially, I just don't understand because you think it happens in New York. How many shootings specifically happen in New York on a daily basis? And how many of those are labeled as an act of terrorism? That's one thing that is
Even
kind of
mass
hard for me to
shootings,
grasp.
even gang related shootings where 4 or 5 people are injured are not labeled terrorists. So, Mark, do you have some insights as to both of these? Number one, the terrorism charge, which I think was shocking to a lot of people, and then number two, New York seems to have a very idiosyncratic way that they do first versus second degree murder.
They do indeed. And it's interesting because this, I think, typically would have been brought as a second degree murder if it were being managed in the way that you both talked about this. The way that, let me take a step back because I was able to look at a very tabloid type piece from the New York Post about the Luigi Mangione timelines and the like. And it was rather frightening how, again, and I'll reflect back because we talked about how Martha Stewart was tried in the court of public opinion at a New York court, same district. And that was just a circus. And that worked in favor at that time for the prosecuting attorney from the state of New York. In this case, the public opinion is very, very much mixed in how this is happening. And again, I think the terrorism charge is sensationalizing what happened here. If you look at the actual terrorism statute and how that works, it's typically more addressed at how public officials would be influenced by this. And this is more of a private citizen and CEOs who manage corporations. I'm missing the context for the terrorism charges. I would expect that his attorney, who is a very, very good attorney with a great reputation, as a side note, her husband is representing P. Diddy, which is a whole other sort of thing that we could probably get into at another time. But the reality is I have every confidence that she'll be able to dissuade the prosecutor from continuing. And if they are charges, I feel she'll be able to defend them very, very well because I don't see the application here. But that, to your point, Ali, is why it ended up going to a first degree murder charge because they're utilizing these special circumstances to push that forward.
Yeah, it's very interesting, and something that a lot of people are pointing out is that the first degree murder charge is really, like you said, is for public officials, is for government officials when you're trying to impact policy using violence. And that's, kind of the same thing that the terrorism charge is about. But he attacked a CEO of a private company. So a lot of people are concerned that the New York State is seeing these private companies almost like they're a part of the government, which really, is the whole opposite of it being private healthcare. If it's private healthcare, it's supposed to be capitalist, it's supposed to be for the benefit of people so that they can have better healthcare at lower prices. But if it's essentially public, if it's essentially there's some kind of integration between these corporations and the government, which seems to be the argument of the New York State, then that's very problematic because that would mean the general public is not getting the benefits of public health care, but they're paying the fees of private. So there's a lot of interesting, wider considerations that are being brought to the fro. But I'm interested looking at, so what with the division of the charges, why are some of them in New York State and why are some of them federal? It seems interesting that he now has two cases. A lot of people would assume you commit one crime, you get one charge in one jurisdiction, but he's got about 8 or 9 charges in both federal and state. So how does that work? How is it possible? How does that not raise double jeopardy concerns?
Well, let's take it first. Let me disclaim something. Luigi Mangione is accused of all these crimes. He is presumed innocent until proven guilty. He is incarcerated as a suspect, but to be clear, he has not been convicted of anything at this point. And then let's step back. There are 3 jurisdictions involved here, and that is the key to understanding why federal charges happened. This is across state lines, and therefore falls under the jurisdiction potentially of federal case law, and in this case brought in the Southern District of New York's federal courts. So the interstate commerce, the trafficking of a gun across state lines, the false documents that he is purported to have had with him, all of those things lead to the federal charges. And understand the jeopardy at the federal level is it would be considered a capital offense, meaning he could lose his life should he be convicted on those charges, and should the federal government's case and then the judge there decide that that was an appropriate judgment in the case. And then he was found in the state of Pennsylvania, of course. So when interrogated by the officers in Pennsylvania, he committed to their charges crimes in the state of Pennsylvania. He was extradited to the state of New York. State of New York, of course, had the charges that they're purporting he had shot the CEO of UnitedHealthcare in New York, et cetera. So that hopefully that helps everyone understand a bit about how the jurisdiction fell and how the charges have come in 2 states as well.
Yeah, it seems like it's also a prosecutorial strategy because if you have all these different charges in New York, Pennsylvania, and federal, then that makes the defendant look really bad. It can take someone that has never, even got a speeding ticket, but from this one accused act, now he's got charges in 3 different districts, or at least in 2 different districts, and then also in federal, and all the charges are different. So this can quickly take somebody from being a law-abiding citizen, then there's one incident, and now he's a career criminal for the purpose of sentencing, which obviously would play into if they wanted to pursue the death penalty, that would be something that they would take a look at.
Yeah, one of the reasons for what appears to be differentiation in charges is the way each state manages their constitution, the way that they promulgate their laws in each of the states. So the charges are very similar when you look at them for how they're being applied to this particular suspect. It does seem to be a mountain of the same evidence, but understand that jurisdictionally, you're very correct. There are 2 areas, specifically the state of Pennsylvania and the jurisdiction within which he was found and then arrested, and then the extradition to New York and then New York state charges. And as we discussed a little bit earlier, the commission of the crime that he is suspected of, crossing state lines with firearm, absconding or leaving the state where he was accused in New York, that led to some of the federal charges as well. So for the layperson, I think it would be very difficult to sort this through. It does look like a mountain of evidence. Understand part of the prosecution in either state and the federal case against Mr. Mangione, they want to show this as an overwhelming amount of criminal activity, but it is all the same sequence of activity. It's just a follow-up pre and post. So coming up from Florida, arriving in the state of New York, supposedly committing the crime in the state of New York, and then fleeing to the state of Pennsylvania brings the federal case into it. I think this is part of the way that they're going to approach publicity in this case for sure.
So we see that on his federal case, they've got the complaint. It was sealed initially. It may still be sealed. Arrest of Luigi Mangione. Notice of his attorney appearance, Mark Antony Agnifilio. A minute entry for proceedings held before the magistrate judge, Catherine H. Parker. So there's been a lot of controversy actually about Miss Catherine H. Parker presiding over this case. And I believe that this is the judge around whom the controversy is. Let me make sure. It may be the state judge. Yes, no, it's her. So there's been a lot of controversy around her because she's actually married to a healthcare CEO, not UnitedHealthcare, but another company. So a lot of people have been speculating that the choice of this particular judge to preside over the case was intentional. Luigi is detained without bail, and there's no prejudice, meaning that he could appeal that, but I don't think he's going to. There was a medical order filed, a Brady order, an order to continue in the interest of justice. So why would his attorney file an order to continue in the interest of justice?
That one I don't know that I can comment on, Ali. That's not one that I actually took a great deal of interest in. To step back, one of the motions that I would immediately bring is to have that judge recuse herself.
Yeah.
I feel that will be coming very soon. As you know, judges have great latitude. I would also follow that by a change of jurisdiction motion as well, but those we'll get to if we have time here. Making sure that we come back to that, but certainly we can come back and talk about the other shortly.
Sure. So Atticus, one of the things that Atticus does is recommends motions for you to file next. So in the federal case, it's recommended a motion for bill of particulars, a motion to compel disclosure of records of electronic surveillance, and a suppression hearing, and then motion to strike matter as surplusage, not relevant and prejudicial. These legal recommendations are crafted not only to advance the immediate defense of Mangione, but to reinforce the principles of due process, ensuring every aspect of the trial remains tethered to robust legal standards that prioritize factual integrity over narrative sway. Such a diligent defense strategy strives to cut through the highly publicized discourse surrounding the case, culminating in trial anchored in evidentiary rigor and procedural fairness. So I don't think Atticus knows we didn't upload those details about the judge. So I definitely think that we would want to go through and file a motion to have the judge recused for sure. But I know you also have some ideas about what we should be doing in the case. And that's one of the beautiful things about the software is that you can go and chat to Atticus and develop a trial strategy and let Atticus know what it is you're thinking. You can also go and just manually select the kind of motion that you want to draft. And all of that updates Atticus so that it understands what approach you as a defense attorney think you should take. So, Mark, based off of your experience, if you were representing Mangione, and we understand that he's got some really incredible counsel right now, what would you do, or what would your recommendations be?
I think I already spoke to two of those. The recusal of the judge for the very reasons that you stated. I think secondarily it would be a change of venue, but that may come a bit later because first and foremost, you want to have a motion to suppress evidence. I agree that a bill of particulars would come. That should be automatic. And then you would want to do discovery and get all of the evidence because as I also spoke to very early when we started talking about this, I want to see how they collected the evidence. I want to know how the video surveillance was taken so that I could start to pick apart how the NYPD got their evidence, whether they or not they were preserving constitutional rights as they moved through that. And so a motion to suppress evidence would come shortly thereafter, after we'd gotten through that discovery for sure.
A lot of people are concerned about the kind of surveillance NYPD is doing in New York. And there's been a lot of suspicion that the reason why NYPD has not discussed how they obtained certain evidence about Mangione is because they're probably routinely violating everybody's civil rights and engaging in a widespread surveillance program in the city of New York. And that's been touched on before, not in this particular case, but now I really think there's a potential for that to come to the fro. And I think any competent defense attorney would really want to frame, hey, look, you're collecting this evidence in a way that not only violates the civil rights of my defendant, but that is violating everybody's civil rights. And so that they would want to argue that that's not admissible.
Absolutely, I agree. I don't know about the extent to which that has been substantiated. So I want to be careful how we approach any allegations of misconduct by NYPD, but I do feel as an attorney, and his attorney is an excellent attorney, we all know that. She will very likely comb through all of that and have several of those responses to how they collected that information. And I have no doubt she will file a very strong motion to suppress a good bit, if not all of that evidence. The technical way, and I think we talked about that very briefly as well, the timeline, though people think it took days, this is not a TV procedural that gets managed in an hour. We live in the real world, and in the real world, collecting evidence is much more difficult, in my experience, than how this came together. And it all fell into place rather significantly and very quickly, in my experience, versus how an ongoing investigation happens. And I've been engaged in many of these cases in the jurisdiction within which I practice, and this is different. I will say it that way. I would definitely attack the way that they collected the evidence.
So on the motion of bill particulars, this is a motion that Atticus drafted, and it goes through each one of the charges, requesting very specifics with some citations that justify why there would need to be more details so that the defense can actually prepare a proper defense. And then this is a motion to strike surplusage, personal and political backgrounds, public perception and media representation, historical associations, affiliations, all of that being irrelevant to the current charges, that having a prejudicial impact on the defendant, discussion of Rule 7, and then judicial precedents about that towards the end of the motion. So, in your experience, Mark, are these kind of routine, important motions that a defense attorney would file? And how long would it kind of take an attorney to prepare that? And how much of an advantage does it give a defense attorney to have software that can immediately not just recommend what to file, but also help you draft it?
Traditionally, going out and doing the research, you'd have to have a team with you, as many as 5 or 6 paralegals and assistants that would help you comb through case law. Getting a starting point, at the very least, with a tool like Atticus AI would be very beneficial, because it could help you manage the tactical approach to the case as you're building out the strategic portions of the case. And the motion that was just developed by Atticus very quickly at least could be a guide for those people you have working in the background and doing the research, to help you hone in how best to utilize that. And in this case, it's going to be very key to manage media, one. Two, public perception has definitely been out there, as I pointed to the New York Post tabloid and their 1 hour presentation of the swift justice to get Luigi Mangione back to the state of New York. This all has an effect on your jury pool. It has an effect on how the perception of the courts are. You start to shade it with a judge who is married to a CEO of a health care company. This starts to paint a very vivid picture of what people might expect in our justice system. And that's, we need to make sure that our justice system at least has the semblance of a fair trial. And the two motions that you just shared would help us move that forward in a very meaningful way.
One of the ones that I haven't drafted yet is a motion to compel disclosure of records of electronic surveillance and for a suppression hearing. That was another one that
Those
I
are absolutely.
remember you mentioning. Yeah, so it takes Atticus about 5 minutes to draft these motions. Ordinarily, it would take a paralegal at least 2 to 3 hours, if not much longer. So
It would
these,
take me longer just to develop that strategy. Just to give you an idea, when I was researching this prior to this, it took me 4 hours to pull together just the summary that we've been talking about. So this is a significant savings of time. And of course, as an attorney, I would read through this, I would add my context to it, and I believe Atticus would then help me hone my strategy moving forward after we get through the tactical approach here of presenting the initial motions.
exactly. So this kind of life cycle management is very important, no matter what you're doing with the legal system, but especially when somebody's life hangs in the balance. I mean, we're talking about a case where there's a possibility after a couple of years, Luigi gets executed. So defense attorneys really need these kinds of strategic support tools. They're not designed to replace a defense attorney or even a paralegal in any sense, but they're really designed to enable them to be able to operate at their highest level. So, with that being said, I'm going to give my personal non-professional, because I'm not an attorney, my thought on how I think the case should go from a defense perspective, and then I'd love to hear some more of your advanced thoughts, Mark. Not just the shorter tactical considerations, but what you think your broader strategy would be. For me, with the amount of pressure that this defendant has on him, with the judge being married to a healthcare CEO, uh, all of this indicates to me that there is a huge interest in this guy getting convicted or possibly even executed. But we know that public sentiment seems to be majorly on his side. So if I were a defense attorney, which I'm not qualified to be a defense attorney, so take this with 2 cents, I would think that one of the strategies we would want to consider is not only taking it to trial and calling into question the evidence and looking at the pictures that they released that clearly seem to be of different people, and also the unconstitutionality by which the evidence was possibly gathered, but just jury nullification, playing towards people's sympathies, because a lot of people don't feel that Luigi is being treated fairly. And a lot of people feel like it doesn't make sense that it's legal to be a healthcare CEO and make these kinds of decisions about people's lives while it's illegal to do what Luigi did. Again, not condoning either side, because this is not an ethical or moral consideration. We're just talking about strategies for trial. It could be possible that the jury will think, hey, you know what? Based on the evidence, it does seem like Luigi did it, but we don't think he should be in jail. So that would be kind of a final nail in the coffin strategy that I would do after exhausting all of the procedural stuff. But I'd love to hear what your overarching approaches would be outside of the more routine, suppress the evidence and things of that nature.
Well, let me just walk through it briefly, and we can have that as a sort of a summary, and then you both can comment as you will. But we already talked a bit about the key defense strategies with the motion to suppress and whether and to what extent any witness statements would be credible. Certainly that would come up at any preliminary hearing. I think those motions will be very important. But moving on, I think there are constitutional challenges for violation of rights. His constitutional rights and protections we've touched on very briefly. I don't know that there would be an entrapment defense of any kind, but certainly I noted that. I don't think that's relevant necessarily in this case. There's been much made of mental health defenses, the extreme emotional disturbance that has been very tabloid managed because he seems mild mannered and very charming. But then when he was arrested and taken into jail, he yelled out and had a very angry face. They're making much of that. And certainly that will play toward some of the media perception and media strategy that would have to be addressed with the trial that I think you just spoke to, Ali. But let's go back and talk a bit about diminished capacity and the like. I don't know that I would use that strategy at all. When he pled not guilty, it was not clear whether or not it was not guilty by reason of insanity. That's, I think, for a later discussion, but much has been made of that. In fact, I heard one commentary that said, clearly, if you're going to commit murder, you're crazy. But we all know that that's not how that's approached. And then secondarily, because of the manifesto and some of the other things that were ancillary potential evidence against Mr. Mangione, that they're saying that was just crazy as well. And I don't know that that plays well with the public, to your point, when we do media relations and get to a jury nullification. Certainly as a defense attorney, would use that for change of venue. Absolutely. But I think we'll have to wait and see how that plays out before I would bring that up. But public perception management is going to be key to this. Having expert witnesses that can speak to how evidence was both collected, one, and two, all the forensic evidence that they claim to have. You know, the discarded items in Central Park that they claim to have been associated with this, the monopoly money and such, the 3D printed gun and the fingerprints, all of those things will be called into question and will be pivotal for the defense in this case. And so expert witnesses would be engaged there. Secondary ideas on, depending on how the case goes, how plea bargaining might happen, you'd have to think about that strategically as well. The lesser included charges we talked about in New York State, for instance, murder in the second degree is much more appropriate in this case, but they didn't use that, which is interesting. And then that also calls into question the double jeopardy that you talked to before, because being charged in the state of Pennsylvania, being charged in the state of New York, and in the federal case, they're going to have to determine how that's all going to sort out, because typically, if you are found not guilty, it would not be in the best interest of one of the other jurisdictions to bring those cases. Likely the lesser included offenses, gun charges and the like, should he be exonerated and found not guilty of the larger, more difficult charges, the murder charges, for instance, there are still gun charges and false identification charges, etc. So I would do a manifesto analysis, make sure that the content interpretation is managed well, both for the media and for the court, especially when you're approaching the jury with that. I would leverage public opinion, because there is a great portion of the public opinion, again, to your nullification point and my venue point, that needs to be managed as well. There's a multi-jurisdictional defense of coordinated strategy to manage the multiple jurisdiction. And then I took down a bit of how I would, in current state of the law and use of some of the tools that artificial intelligence offers, tools like Atticus AI, to help formulate a strategy for scenario modeling, for instance, because that would help me both tactically and strategically to hone in on best efforts there. Argument generation could be used, certainly with Atticus AI. I would use other tools to do sentiment analysis and to help with social media monitoring. That's not part of what this tool does, but certainly that's something as an attorney that I would like to avail myself of, because that technology exists now. There are ethical considerations, of course, in using AI. We don't, as a tool, Atticus is not just an AI tool. It's actually, to your point, Ali, a life cycle case management platform that allows you to feed your information as an attorney into the tool and build a tactical and strategic a tactical and strategic approach to how to manage a case like the Mangione case. And then there are several others, but legal ethics is the bottom line for any attorney. Making sure that you're zealously defending your client and ensuring that there's a fair trial for him, which I think feeds back to some of the emotions and some of the tactics we've discussed as we've gone through this half hour together.
So I really want to get Dakota's perspective. Dakota is our chief revenue officer, so he's not a legal expert per se, although he is an expert in his field. But from your vantage point, Dakota, what do you think about this case? What do you think about Luigi? What do you think about the details of the case? What do you think about how it's being handled? I'd love to get your insights.
For sure. And like you stated, I'm not an attorney, haven't practiced in law, but just from like a common everyday person's perspective, I think there's a lot of things that are super easy to question in how everything went down. Like we talked about it before with like are these charges how do these charges generally come up in the state of New York, and why is it so different for Luigi himself? And then it plays into the aspect of, okay, is it because there was a CEO involved? Is there some kind of special treatment that they get versus the everyday person who, is either a product of crossfire or, was actually targeted? There's so many different parts and moving pieces to this case that for someone like me who doesn't understand it, even having Atticus at my disposal to help kind of summarize everything gives me a better idea. But there's just a lot of questions that come into play here. And then the trial by media factor, where you have every outlet having their own comments on this case, and it's bringing it to light. And from what I've seen in the news and everything else, like it's almost like he's presumed guilty. Like it's putting it in your brain as more reports come out that he is guilty, even though nothing has been decided. Everything is alleged at this point. So it's just, I don't know. To me, I guess confusing is a good way to put it, but there's just like a lot of red flags that come to mind, which is kind of why I like to have even access to Atticus myself to get a little bit more clarity on those aspects.
You brought up a really good point, which is in the past, I think everybody was really dependent on news and traditional media sources. And so now that everybody can go on the internet and go on other places, it's kind of frightening to see all of the media unanimously declare this man to be guilty when the public sentiment is very much on his side. And just looking at the disparity, it really reinforces that for a long time we've been beholden to these opinion makers that maybe didn't have our best interests in mind. So that was a really interesting point that you brought up.
Yeah. I mean, there's a lot of things. It's like even and again, it's just my own thought process, but like the vilification of himself versus like actual context. Okay, if these news outlets want to say that it was premeditated, what were the driving factors for that? Why isn't that being talked about just as equally as what he may have or may not have done, to get to where he's at today? So there's just there's a lot that raises a lot of different questions in my mind, just from a normal everyday person's point of view.
No, that was great. That was really insightful. So
I,
we're going
I
to
totally
continue to
agree.
monitor. Go ahead, Mark. Sorry.
I was just going to say, Dakota, I think you are representative of a very tempered approach that we're not necessarily seeing out in the world. You're looking at it from both sides, but also looking at it and both of you, from the overarching societal approach. And one of the things that I think isn't taking into consideration is we as a country have a romantic history with outlaws. It goes back to you know uh, the lawmen of the past. You can talk about the OK Corral. You can talk about Billy the Kid. These are folk heroes as much as Daniel Boone and the things that happened down in Texas at the Alamo. But then bringing it more so to the outlaw romanticized. I think that is part of what's going on that would go to the jury nullification, because honestly, Bonnie and Clyde, and all of those outlaws who robbed banks when banks were perceived to be against the public. They were cheating people. There's a public perception perhaps out there that our healthcare system is not treating human beings like human beings, and they're using AI. And I thought that was an interesting take that we could get to at another time. But they use AI to deny these claims, and we're using it to help defend. And it's just an interesting concept right now. One other quick note, and I think you both have probably been influenced to this degree as well. When I got out of law school, I said it absolutely ruined TV for me. Because every police procedural that you see on TV is so full of crap, I will say. It's not how the system typically goes. There are some that are better, some that are worse, but that's how we in the United States have been conditioned to understand how this works. And that's just not how it works in the real world. It's very dry. I mean, go and watch a trial, an everyday trial. Being a litigator for some time, it was not fun. It was very dry, very boring. And so the salacious aspects of this are very appealing because we see it on TV and we've been conditioned to do that. So all of the things that we've discussed here, both of you having very, very quality takes on how this is working. I'd have to say, rather than a legal mind, your minds are the ones that are going to help sway public opinion on this rather than how the lawyers will have to sort through this. And I think New York's tactics have been, the perp walk with the mayor, who's basically a criminal himself. I'm sorry, that's my opinion on that. It's just the whole way that we approach this is very tabloidy. It's very sensational. And it's not a good commentary on our justice system at all.
Yeah.
And that's, we can edit that out if you wish or whatever. But honestly,
I agree 100%.
It's just insane.
So
that's just my personal opinion, not my legal opinion. How's that?
we're gonna keep following this case. We're gonna, whenever there's updates, we'll meet together, talk about it more. But we really appreciate you spending your time to gain more insights, not only to the case, but also to see how our revolutionary technology can help defense attorneys challenge cases that are problematic like this one. And we hope to see you guys soon. Please like, subscribe, and share. Thank you. This is Ali signing off for Juris AI.
Thanks, Ali. It's happy to be here.
It's been a fun one.
Definitely has. Thank you.